of 16 years, except for his siblings, and that was dependent upon David Moore's report. And I, in fact, have a copy of that. I believe everyone else does, Mr. Watt, Mr. Coleman, and Ms. Barron. In that, they did not, Mr. DeMore did not find Mr. Katagis to be a high risk. In fact, when he went on, he seemed to minimize that this was something that happened while he was an adolescent, and there was no indication that he would in fact be an adult pedophile. Also, there would be no contact with the victim unless the victim initiated that. And I believe David Moore's report, which was encompassed into the PSI, they talk about contact being initiate no contact with the victim, and the victim desires contact to determine the frequency and type of the contact. And there's also the psychotherapy, the licensed therapist, being appropriate by treatment providers. Now, he's going to be on probation with treatment. Now, as far as he's not going to be going to connection as an adult, as Mr. DeMore says that's not the proper form for treatment. He may have to engage his own therapist.
You always talk about that in the addendum, and I think the discussion we had had at the time of the plea was that because of the mental health counseling or no sex offender treatment on the record, that would qualify when we talked to him about trying to arrange some counseling and just getting the okay of a probation. We had that conversation this morning.
And I was as far as once you find out who his treater is going to be, that you give the treater a copy of Dave DeMore's report, which I think would be very helpful regarding any type of therapy for Mr. Katagis. Does that agree, Ms. Bowman?
I have no problem with that, Mike.
Mr. Waller, I'll hear from you, I'll hear from Ms. Barron. I have Mr. Katagis, if you wish, and we'll go from there. Thank you. I did receive a letter from Anastasia Antar, who is a brother of Mr. Katagis.
Sister.
I'm sorry, Anastasia, I'm sorry, apologies. Thank you, Mark.
Somebody walked into this courtroom at this moment, they would probably think this is just another sentencing in connection with a type of offense that is dealt with in this courtroom, both by counsel and Your Honor. Probably the thought might well run through their mind that when it comes to our system, oftentimes it's said that there are really insufficient resources, insufficient personnel to properly deal with a lot of the issues that often come as part of these type of offenses and the underlying criminal conduct. They would be sorely mistaken, I would submit, at least in connection with this case. Your Honor is well aware of the somewhat tortured history of this matter and the amount of time and effort that was devoted by everyone in connection with this case on both sides of this matter in trying to reach what hopefully would be a fair and appropriate sentence in connection with this matter. There was a lot of time devoted to matters and issues that were not directly related to the criminal conduct itself. All the thought that let's see if we can make the situation better, particularly for the victim in this matter, but also the thought that let's not overly penalize the defendant in connection with the case. Your Honor is aware, I'm sure, that this matter did proceed to trial. A jury had been selected. Evidence was ready to commence. And on both sides approached, Your Honor, with a proposed disposition. First,
family situation and certainly did not want anything that would make it worse or estrange any family member from the other to the best of her ability. She fully cooperated with me and Attorney Waters. We've met numerous times over the weekends. We've met here. We invested a lot of time to ensure that she was satisfied, that she was heard, and that a fair outcome was reached. She was fully prepared to go to trial and testify, and I believe that this is certainly a better outcome for all parties involved. This statement is, I would just like to express my relief that this matter is finally coming to a close. I've gone through a great deal of stress during the legal process involved in this case, and I feel as if the disposition of this matter is a fair one. I wish the best for Christopher in the future, and I look forward to moving on with my life once and for all. Thank you, Theodore Antar. I also ask the court to impose the agreed upon sentence on the underlying plan. Thank you.
Okay, Jim, the victim's name is redacted from the record. Any further, Mr. Rock? No. Ms. Pope?
Is there something else, John?
Record placed in the file is the, under seal, is the victim of sexual assault, and her name is disclosed in there. Okay. Yeah. Thank you. Ms. Pope?
Yes, sir. Thank you. I think that I think all the lawyers here have been practicing a long time. This was a particularly difficult case because of the family constellation of my client's role in basically being the financial supporter of his family, his mother, his half siblings, and I do think that it is unusual for Your Honor to take a plea in a case where jury's already been selected, and I appreciate also your flexibility in allowing us to come back to you after having spent 2 weeks picking a jury to resolve this case, because I think Mr. Waddick and I agree that whatever the outcome, it would have been a train wreck for the family. This case proceeded to trial. So I do think it is an appropriate resolution, a disposition. The only thing I would add, Your Honor, is that the court, because of my own experience with probation in the past, is that the court explicitly put on the record that there's to be no sex offender treatment, because otherwise probation, as the court knows, will go off on its own on that issue. I think otherwise the terms outlined at the time of the plea, which Your Honor just reiterated, are appropriate conditions. I think you did make a finding at the time of the plea, but I think you probably have to, again, under the sex offender registration statutes 54-255, parentheses B, that it will be a non-public registration and reasons therefore.
Mr. Katagis, you want to say anything, sir? Okay, on the charge of risk of injury, sir, you're committed to custody and care of the Commissioner of Corrections for a period of 5 years, and suspended and placed on probation for 5 years. Under sex clause, 1 year suspended, 3 years of probation to run concurrent. Total effective sentence is 5 years suspended and 5 years of probation. I'm sorry, that was 5 suspended and 5 probation also to run concurrent. There's not much I can say about this. This case was around for quite some time. We discussed it at great length. My major concern in this matter was really not you. It was really the young girl, the alleged victim of this matter. The dynamics of your family came into play because when you ended up going back into the house and the young girl left the house, that was done so that you can work and support the family rather than see the house going to foreclosure. And really, for some time, until this baron got involved and really pushed DCF, the young girl was not only victimized once with you, but she was again being victimized by our system. traumatic impact on the girl on the while she's graduating from high school and she goes on to college. She has quite a little of all in all of her now. In any event, in addition to probation as outlined in the addendum to the PSI, one, you'd end up, you'd have individual psychotherapy with a licensed therapist. A copy of the report submitted by Kathleen Savino and reviewed by Dave DeMore will be given to the therapist, and I would suggest that within 30 days you end up engaging in that type of treatment. The name be given to probation, and probation will give a copy of this report to that therapist. Mr. DeMore does say that you do not appear to be an appropriate candidate for adult sex offender treatment, so that is not being ordered. Sex offender treatment will not serve your needs adequately at this time. You're also to comply with any referrals for additional services that are deemed necessary by your therapist. You're to initiate no contact with the victim. Now, the conclusion in the PSI regarding initiate no contact with the victim states that the victim desires contact. Now that is not complete compliance with what Mr. DeMore recommends or Ms. Savino, where they're saying no contact unless initiated by the victim. Contact is desired. Both the victim's treatment provider and Mr. Katagis' treatment provider must be in agreement that the contact is suitable. Do you want that as a condition?
Well, Your Honor, I want to say something about that because I understand the part of it that he's not to initiate any contact. But I think the problem here is even if the victim wants contact, he may not. And I don't think that we should set up a situation where he could violate his probation by not wanting contact. That's what we understand. But the way he wants contact. Right, that's why I was concerned about the phrasing. I think it needs to be phrased so it's clear that he's not under an obligation to have any contact. I understand why this is in here, to allow it if both parties want it. Well, it's true, but I just want to make it clear that it's not what I said.
But I think it's there, so it's clear that, let's just say it's a family function that everyone's going to attend.
Okay.
And the young girl wants to attend. And her therapist says it's okay for her to go there. She can attend the function. What that means is that your client does not have to leave the function. He does not have to go up to her, talk to her, be nice to her. He can avoid her if he wants. But it will not stop her from attending. Usually when you say that no contact with the alleged victim, that means if she walks in the room, he's got to go out of it. There's no obligation on his part. If she wants to attend the family function where he's present now, he can remain.
Okay.
If he wants to talk to her, fine. If he doesn't want to talk to her, that's fine too. He has no obligation to attend a young lady, even though he attends that function. So I'm going to put in that the no contact with the victim unless initiated by the victim. If initiated by the victim, the defendant still does not have to have contact. If contact is desired by the victim, both the victim's treatment provider and the defendant's treatment provider must be in agreement that the contact is suitable. And the victim would be allowed to determine the frequency and type of contact. Now that will mean that if in fact she wants to talk to your client, and the treatment provider say it's okay, your client said, I don't want to talk to her. That is. If he said he wants to talk to her, then she decides the frequency and the type of contact. But it's a two-way street. It's not a one-way street.
But it does have to be initiated to her treatment provider.
Well, you want to initiate it, and it's got to be agreed upon by both treatment providers.
Right. That's
And it follows to a transfer to the secretary of the file. Then we have place to maintain his employment. Also, there's registration as a sex offender for
10 years.
10 years, and for reasons previously stated that they are in fact related. released today, plus there's a sex fine of $151. It's going to come out to be